Dear students, Namaskar. As last time we discussed Article 22. In that article, although I have got declared that it's all for Article 22, but I sincerely regret that I have got skipped to discuss one most important case law which relates to Article 21 as well as Article 22 of the Constitution. I was under this impression that perhaps I might have got covered this case law under Article 21, but a little bit I realized later on that perhaps I could not discuss it. So that's why, okay, in case if I got covered, then it's fine. In case it will be repetition, no doubt. But in case I didn't cover, then I'm going to cover that most important case law, which relates to Article 21 and 22 of the Constitution. That case law is the D.K. Basu versus State of West Bengal. D.K. Basu in D.K. Basu versus State of West Bengal, we can say that it is the case which had been taken as very renowned and famous case after the case of Joginder Kumar versus State of UP, which I have got discussed in my last lecture, and the guidelines which have been laid down by the Honorable Supreme Court in Joginder Kumar, all those have been elaborated, or rather, we can say that all those have been expanded in the light of all those lapses or all those, you could say, uh, infirmities which could not be cured in Joginder Kumar. And it's both cases, you know, that all of you know that it relates to the uh, torture, physical torture, as well as mental agony to the accused uh, during police custody. And here it's the case which was filed by one NGO in West Bengal, and this NGO, which had addressed a letter to Chief Justice of India, drawing his attention to certain news items published in the Telegraphs dated 20th July 1986, 21st July 1986, and 22nd July 1986 in the Statesman, Indian Express, dated 17th August 1986, regarding the deaths in police lockups and custody. The executive chairman, after reproducing the news items, submitted that it was imperative to examine the issue in depth and develop a custody jurisprudence and formulate modalities for awarding compensation to the victims or the family members of the victims for atrocities and death caused in police custody or police lockup, to provide for accountability also of the officers in charge or concerned. It was also stated that in letter that the efforts are often made to hush up the matter of lockup deaths, and thus the crime goes unpunished. and policies. It was requested that the letter, along with the news items, be treated as a writ petition under public interest litigation. Here, the Supreme Court, considering the importance of the issue raised in this letter and being concerned by frequent complaints regarding the custodial violence and deaths in police lockups, the letter was treated as writ petition, and that's why the notice was served. A notice was issued on 9th of February 1987 to the respondents. While the writ petition was under consideration, again a letter addressed by Mr. Ashok Kumar Zohri on 29th July 1987 to the Honorable Chief Justice of India, drawing the uh, attention to the Supreme Court to the death of one Mahesh Bihari of Pilkhana, Aligarh, in police custody was received, and that letter was also treated as writ petition and was directed to be listed along with the writ petition filed by Mr. D.K. Basu, and D.K. Basu on 14th of August 1987. Here, the court made some observation and stated that in almost every state there are allegations, and these allegations are now increasing in frequent of deaths in custody described generally by newspaper as lockup deaths. So those uh, at present there does not appear to be any machinery effectively to deal with such allegations. So since this is an all India questions concerning all states, it is desirable to issue a notice to all the state governments to find out whether they desire to see anything in the matter, and let notice issue to all the state governments, let notice also issue to the Law Commission of India with a request that suitable suggestions may be made in the matter. Notice be made returnable in 2 months from today. The importance of affirmed rights of every human being need no em- emphasis, and therefore to debtor breaches thereof becomes a sacred duty of court as the custodian and protector of the fundamental rights and basic human rights of the citizen. Custodial violence, including torture and death in lockups, strikes a blow at the rule of law, which demands that the powers of executive should not only be derived from law but also that the same should be limited by law. Custodial violence is a matter of concern. It is aggravated by the fact that it is committed by persons who are supposed to be the protector of the citizens. So it is same for the society. So it is committed under the shield of the uniform and authority in their authority in the four wall of the police station or lockups, the victim being totally helpless. The protection of an individual from torture and abuse by the police and other law enforcing agencies or enforcing law or enforcing officers is a matter of deep concern in a free or democratic society. So these petitions raise important issues concerning to the police officers or police powers, including whether monetary compensation should be awarded for established infringement of the fundamental rights guaranteed under Article 21 and 22 of the Constitution in India. So issues were fundamental, and the torture has not been defined in the Constitution or in other penal laws. The torture of a human being by another human being is essentially an instrument to impose the will of the strong or the weak by the sufferings. So the word torture today has become synonyms with the darker side of the human civilization. So in all custodial violence, what is a real concern is not only infliction of body pain but the mental agony which a person undergoes within the four walls of the police stations or lockups, whether it is physical assault or rape in police custody. The extent of trauma a person experiences is beyond the purview of law. So the custodial violence and abuse of police power is not only peculiar to this country, but it is widespread. It has been concern of international community because the problem is universal and is almost challenge is almost global. So the Universal Declaration of Human Rights in 1948, which marked the emergence of a wide strain of protection and guarantee of certain basic human rights, stipulates in Article 5 that no one shall be subjected to torture or to cruel, inhuman, and degrading treatment or punishment. And you know that this provision we also referred, the court has also referred in Selvi case also when we discussed last time, you know, the last time article 20 of the Constitution. So Article 20 clause 3 of the Constitution. And fundamental rights, here the Supreme Court mentioned that fundamental rights are occupy a place of pride in Indian Constitution. Article 21 provides that no person shall be deprived his right to life and personal liberty except the procedure or except to the procedure according to the procedure uh, established by law. Now, personal liberty, thus a sacred and cherished right under the Constitution. The expression personal liberty has been held to be include the right to live with human dignity also, and this that it that thus it would also include within itself a guarantee against a torture and assault by the state or by its functionaries. Article 22 guarantees the protection against arrest and detention in certain cases and declares that no person who is arrested shall be detained in custody without being informed on the grounds of such arrest, and he shall not be denied right to uh, the right to consult and defend himself a legal petitioner of his choice. Clause 2 of Article 22 directs that the person arrested and detained in custody shall be produced before the magistrate within 24 hours or before the nearest magistrate. excluding the times necessary for the journey from the place of arrest of courts of the mistake of the magistrate. And as I got mentioned, this Article 20 Clause 3 also, uh, lays down that the person accused of an offense uh, shall not be compelled to be a witness against himself. So there are, lot of constitutional safeguards which talks to protect the rights of the arrestee person, or talks to protect the fundamental rights or human rights of human rights of an accused of an offense or of the arrestee person. And here, not only the constitutional safeguards, it's our CRPC 1973 deals with the power of arrest and had safeguards which are required to be followed by the police officers. And it's a lot of provisions of CRPC uh, which deals with the protection protection or in the interest of arrested person, like article like section 41, like section 46, under section 49, section 50, and section it's section 56, and so on. We can say that necessary delay, and section 57 clause 2 of article uh, clause 2 of article 22 of the constitution. Also there are some other provisions like section 53, 54, 167, which are aimed at affording procedural safeguards to a person arrested by the police. Whenever a person dies in custody of the police, section 176 requires the magistrate to hold an inquiry into the cause of death. However, in spite of or despite of the constitutional and statutory provisions aimed at the safeguards of the personal liberty and the life of the citizens, growing incidents of torture and deaths in police custody has been one kind of alarming factor, or it is a disturbing factor. Experience shows that worst violations of human rights take place during the course of investigations, when the police, with a view to secure an evidence or confession, often resorts to the third degree methods, including torture, and adopts techniques screening arrest by either not recording the arrest or describing the deprivation of liberty merely as a prolonged interrogation. So, a reading of morning newspaper almost every day, carrying reports of dehumanizing torture, assault, rape, and death in custody of police or other government agencies, indeed depressing. So, the increasing incidence of torture and death in custody has assumed such alarming proportion that is affecting the credibility of the rule of law and administration of criminal justice system. So the community rights feels perturbed. Society's cry for justice becomes louder. And here, regarding the uh, police torture during investigation, or the in the pretense of investigation and interrogation, it's the itself third report of the National Police Commission in India expressed its deep concern with custodial violence and locks up deaths. It appreciated the demoralizing effect which custodial torture was creating on the society as a whole. It made some very useful suggestions. First, that the cases involves a grave offences like murder, dacoity, robbery, rape, etc. It is necessary to arrest the accused and bring his movements under the restraint to infuse confidence among the terror-stricken victims. Second, the accused is likely to abscond and evade the process of law. Third, the accused is given to a violent behavior and is likely to commit further offences unless his movements are brought under arrest. Uh, Fourth, the accused is habitual offender and unless kept in custody he is likely to commit similar offence again. It would be desirable to insist through departmental instructions that a police making an arrest should also record in the case diary of reasons for making the arrest and thereby clarifying the conformity to the specified guidelines. So, all these recommendations reflect the constitutional commitments of the fundamental rights to the personal liberty and freedom. So, these recommendations, however, have not acquired any statutory status. Here again, referring the important case law, which we have got discussed earlier, with the case law of Jogendra Kumar, which is the state of UP, and here I'm going to repeat, and I'm going to reveal the facts that here it was the case of one practicing lawyer who has been remained the prey of torture, torture of police lockups, and you know that there was no whereabouts of him for around 4 days, despite of the repeated requests by the relatives of the practicing lawyer. Ultimately, that one writ was filed, habeas writ was filed to the Supreme Courts, and that uh, it's the Supreme Court because the police version was that during because he was remained in police custody around for 5 days from 7 January 1994 to 14th January 1994 means that the lawyer was not in detention. The police versions assisting the that what was the police version that 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 during this period the lawyer was not in detention at all, but was only assisting the police to detect some cases. But the detainee asserted otherwise. The court was not satisfied with the police version, and it is noticed that though as on that as on that day the writ or the relief in habeas corpus petition could not be granted, but the question whether there had been any need to detain a lawyer for 5 days, and if at all he was not in detention, then why was the court not informed? So here, that there were important questions which required an answer. Besides, if there was a detention for 5 days, for what reason was he detained? For what reason was he detained? The court therefore directed the district judges Ghaziabad to make a detailed inquiry and submit its reports within 4 weeks. So the court voiced its concern regarding complaints of violation of human rights during and after arrest. And, the court said the horizon of human rights is expanding. At the same time, the crime rate of also increasing. Of late, this court has been receiving complaints about violation of human rights because of the indiscriminate arrests. So, how are we to strike a balance between the two? So, that it's one case and another case also, which relates to uh, uh, police torture. That was that was the case of so custodial arrest is one of the worst crime in civilized society, governed by the rule of law. The rights inherent under Article 21 and 22 of the Constitution requires to be jealously and scrupulously protected. We can't wish away the problem. Any form of torture or cruel, inhuman, or degrading treatment would fall within the inhibition of Article 21 of the Constitution. So, whether it occurs during investigation, interrogation, or otherwise, if functionaries of the government becomes lawbreaker, it is bound to breed contempt of law and would encourage the lawlessness, and every man would have the tendency to become a law unto himself, thereby leading to anarchism. So, no civilized nation can permit that to happen. Does a citizen set off his fundamental rights to life the moment a policeman arrests him? Can the right to life of a citizen be put in abeyance on his arrest? So, these questions touch the spinal cords of human rights. Touch the spinal cords of human rights jurisprudence. So the answer indeed has to be emphatic no. No. The precious rights guaranteed under Article 21 of Constitution cannot be denied to convicts under trials, detainees, and other prisoners in custody except according to the procedure established by law. By placing such reasonable restrictions as are permitted by law. So here again the Supreme Court referred another important case law which related to the uh, police torture or custodial violence related to uh, deaths, rapes, and severe physical torture. In other cases also, like the landmark case which has been referred by the Supreme Court in this case, it is the case of Nilavati Behra versus State of Orissa, where the court pointed out that the prisoners and the detainees are not denuded, denuded of their fundamental rights under Article 21, and it is only such restrictions are permitted by law which can be imposed on the enjoyment of fundamental rights of the arrestees and detainees. And it was observed, uh, it is axiomatic that convicts, prisoners under trials are not denuded of their fundamental rights under Article 21, and it is only such restrictions as are permitted by law, which can be imposed on the enjoyment of fundamental rights by such persons. But it is an obligation of the state to ensure that there is no infringement of in no infringement of indefeasible rights of citizens to life except in accordance with the law or while the citizen is in its custody. So the precious rights granted under Article 21 of the Constitution cannot be denied to the convicts under trials. or other persons in custody except according to the procedure established by law. There is a great responsibility on the police or prison authorities to ensure that the citizens in its custody is not deprived of his right to life. His liberty is in the very nature of things circumscribed by the very fact of his confinement, and therefore his interest in the limited liberty left to him is rather uh, precious. The duty of the care on the part of the state is strict and admits no exception. The wrongdoer is accountable and state is responsible if the person in custody of the police is deprived of his life except according to the procedure established by law. Here, uh, Supreme Court also referred another important case law, uh, which was the case of State of MP versus Sham Sundar Trivedi. Here, uh, we can say it's another very sensitive case, which opened the eyes of the society. How the police department is going to misuse the misuse its power in the pretense of the power of investigations and interrogations during at their police lockups. In this case, one Nattu Banjara was arrested by the police, and he was so severely beaten and interrogated that he was died. And later on, in morning, as per the version of the police, that he was found uh, near the one uh, wriggling tank or tank wriggling, and it was stated by one police constable that he was uh, crying because out of chest pain. But when the constable approached him, then he stated that he was died. He was found died. And when uh, and even he was committed by the police department declaring unknown. When this when this episode was brought to the notice of the administration, then the one uh, administration, then the prosecution started a case against the police officers, against the police personnel under various sections of IPC, like 218, 201, 342, and 302, 149, and 147 of IPC. And here, what happened that at the initial stage of prosecution, which was happened in the court of ADG, ADG, or first additional session judge, acquitted all the respondents of all the charges, holding that there was no direct evidence to connect the respondents with crime. Then the state government went up in appeal in high courts against the order of acquittal, and high courts maintained the acquittal of respondents 2 to 7, but set aside the acquittal of respondent 1, who was the in charge of police station, Mr. Shamsundar Trivedi for offences under 218, 201 and 342 IPC is acquittal for the offences under 302, 149 and 147 was, however, maintained. The state filed appeal in Supreme Court under SLP, and the court found that following circumstances had been established for the prosecution beyond every reasonable doubt and coupled direct evidence uh, and the and you know that direct evidence of private witnesses 1, 2, 1, 3, 4, 8, and 18. Those circumstances were consistent only with the hypothesis of guilt of respondents and were inconsistent with their innocence. So here the Supreme Court, uh, they allowed the appeal, and ultimately, that the Supreme Court allowed the appeal, and the acquittal of respondents 1, 3, 4, and 5 was also set aside. The respondents were convicted for various offences, and including the offences under Section 304, Part 2, Section 34 of IPC, and sentenced to various terms of imprisonment and fine ranging from 20 to 50,000. The fine was directed to be paid to the heirs of Nathu Banjara by way of compensation. So, uh, after this case, uh, another case which was important case, which was referred by the Supreme Court, it was the death of Swinder Singh Grover, and here the Supreme Court particularly quoted that apart from the police department, there are several other government authorities also, like Directorate of Revenue Intelligence, Directorate of Enforcement, Coastal Guards, CRPF, BSF, Central Industrial Security Force, CISF, the State Armed Police, intelligence agencies like the uh, Intelligence Bureau, RAW, CBI, CID, Traffic Police, Mounted Police, IT, ITBP, which have the power to detain a person and to interrogate him in connection with the investigation of economic offences under the Essential Commodities Act, exercise, exercise, excise and customs act, FIRA. So these are the instances of torture and deaths in custody of these authorities as well. And in this case, you know that it was the death of Swinder Singh Grover. Uh, Here, 19, the Justice the court took the show moto notice of the death of Swinder Singh Grover during his custody with the Directorate of Enforcement after getting an inquiry conducted by the additional district judge, which disclosed a prima facie case for investigation and the prosecution. This court directed the CBI to lodge an FIR and institute a criminal proceeding against all persons named in the report of the additional district judge and proceed against him. So the Union of India Directorate of Enforcement was also directed to pay rupees of 2 lakhs to the widow of the deceased by the way of ex gratia payment at the interim stage. And that amendment of the relevant provision of the law to protect the interest of the arrested person in such cases to its chairman made. So after citing and going through the decisions which has been made by the Supreme Court time to time, now the Supreme Court felt that it is the need of the hour that in addition to the statutory and constitutional requirements to which we have made a reference, we are of the view that it would be useful and effective to structure appropriate machinery for contemporaneous recording and notification of all cases of arrest and detention to bring in transparency and accountability. It is desirable that the officer arresting a person and should prepare a memo of his arrest at the time of arrest in the presence of at least one witness who may be the member of the family of the arrestee or the respectable person of the locality from where the arrest is made. So the date and time of arrest shall be recorded in the memo, which must also be countersigned by the arrestee. So we therefore, the Supreme Court concluded that or held that we are therefore considered it appreciates the issue the following requirements to be followed in all the cases of arrest or detention till the legal provisions are made in that behalf as preventive measures. The first important recommendations or guideline made by this landmark decision that the police personnel carrying out the arrest and handing handling the interrogation of a arrestee should bear accurate, visible, and clean and clear identification and names tags with their designation. The particulars of all such police personnel who handle interrogation of the arrestee must be recorded in a register. Second, that the police officer carrying out the arrest at the arrestee carrying out the arrest of the arrestee shall prepare a memo of arrest at the time of arrest and some and such memo shall be attested by at least one witness. One may either be member of the family of the arrestee person or the respectable person of the locality from where the arrest is made. It also be countersigned by the arrestee and shall contain the time and date of arrest. Third, a person who has been arrested or detained and is being held in custody in police station or interrogation center or other locks up and other lockup shall be entitled to have one friend or relative or other person known to him having interest in his welfare being informed as soon as practicable. As you know that this guideline also has been laid down by the Supreme Court in Joginder Kumar case, that he has been arrested and being detained at the particular place unless the attesting witness of the memo of arrest is himself such a friend or relative of the arrestee. The time place of arrest and venue of custody of an arrestee must be notified by the police officer where the next friend or relatives of the arrestees lives outside the district or town through the legal aid organizations in the district and police station of the area concerned telegraphically within a period of 8 to 12 hours after the arrest. So, the person arrested must be made aware of his right to have someone informed of his arrest or detention as soon as he is put under arrest or is detained. An entry must be made in the diary at the police station, at the diary at the place of detention regarding the arrest of the person, which shall also disclose the name of the next friend and person who has been informed of the arrest and names and particulars of the police officials in which custody the arrestee is. So the arrestee should, where he so requests, be also examined at the time of his arrest and major and minor injuries, if any, present on his or her body must be recorded at that time, and the inspection memo must be signed both by the arrestee and the police officer affecting the arrest, and its copy provided to the arrestee person. The arrestee should be subjected to the medical examination by a trained medical doctor by by every 48 hours during his detention in custody by doctor on the panel of approved doctors appointed by the Director Health Services of the state or union territory concerned. Director Health Services should prepare such a panel for all tehsils and districts as well. Copies of all the documents, including the memo of arrest referred to above, should be sent to the Ilaka magistrates for his record. The arrestee may be permitted to meet his lawyer during interrogation, though not throughout the interrogation. A police control room should be provided at all the district and state headquarters where information regarding the arrest and the place of custody of the arrestee shall be communicated by the officer causing the arrest within 12 hours of the effecting the arrest, and at the police station police control room it should be displayed on a conspicuous notice board. So failure to comply with the requirements here above mentioned shall, apart from rendering the official concerned liable for departmental inquiries, liable for departmental action, and also render him liable to punishment for contempt of court, and proceedings for contempt of court may be instituted in any high court or the country, so having territorial jurisdiction of the matter. So the requirements referred to the above flow from Article 21 and 22 of the Constitution and need to be strictly followed. So these would apply with equal force to other government agencies also, to which the reference has been made earlier. You know that. So these requirements are addition to the constitutional safeguards and statutory safeguards, and do not detract from the various other directions given by the courts from time to time in connection with the safeguards of the rights and dignity of the arrestees. So, you know that here we can say that it is all these guidelines were laid down, and uh, And again, you know that here is it's the uh, what happened that in this DK Basu, in which the court observed that more than 7 months have been lapsed since the directions were issued. Through these petitions, Dr. Singhvi, the learned amicus curiae, who had assisted the courts in the main petition, seeks a direction calling upon the DG of Police and Home Secretary of every state, union territory to report this court compliance of above directions and the steps taken by All India Radio and national network of Doordarshan for broadcasting the requirements. So we direct the registry to send a copy of these applications together with a copy of this order to respondents 1 to 31 to have the reports from the Director General of Police and Home Secretary of the State or Union Territory concerned and sent to this court regarding the compliance of above directions concerning arrestees. So the report shall indicate in a tabular form as to which the requirements has been uh, to this the report shall indicate in a tabular form as to which of the requirements has been carried out and what manner, as also which are the requirements which still remain to be carried out and the steps being taken for carrying out those. So the report shall also be obtained from the directors of All India Radio and Doordarshan regarding broadcast made. So you know that in this landmark decision, very important guidelines have been made by the Supreme Court for regulating the discipline in the police departments, especially related to the torture or related to the custodial violence at police station or police lockups could be uh, short or the menace of all this torture could be curbed. So it was a very landmark decision and uh, which had created impact on the custodial jurisprudence and tried to give reforms in the police administration as well as in the prison administration and as well as in the administration of other law enforcing agencies like you know like your other than police departments like RAW, CBI, CID, Customs, FIRA, etc. So it's all about this landmark decision. Thank you. Right now, I would like to discuss another one important case uh, which relates to Article 21A of the Constitution. And as we discussed earlier, that when we enforced our Constitution, the right to education has not been declared as a fundamental right. Although under Article 45 of the Constitution, one provision was made, one provision was made that states shall endeavor to provide within a period of 10 years from the commencement of the Constitution for free and compulsory education for all children until they complete the age of 14 years. And in the light of this directive principles under Article 45, the Supreme Court has emphasized the importance of right to education. And as we discussed in one landmark case, it was the case of Unnikrishnan case, in which the Supreme Court held that although it, the right to education is to be covered under Article 45 of the Constitution, but it's not a simple right. It's the fundamental rights of the citizens, and that's why it's the Parliament which had introduced 86th Constitutional Amendment 2002, which inserted uh, Article 21A, which assured and guaranteed for fundamental rights to all the children from the age 6 to 14, and it was the duty of the state to provide them free educational right or title right to education and provide them free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may by law determine. And related to Article 21A, in which the validity of Article 21A as well as the validity of other law which were enacted by the Parliament for the purpose of enforcement of the provision of Article 21A in our Constitution. And we are going to discuss now one case which relates to Article 21A of the Constitution. That's the case of Pramati Education and Cultural Trust versus Union of India. It was the case of 2014, and here the validity of Article 21A of Constitution, contention of the Learned Counsel for the petitioners. The second substantial question of law which we are called upon to decide whether by inserting Article 21A by the Constitution or by the 86th Constitutional Amendment 2002, the Parliament has altered the basic structure or framework of the Constitution. Before we discuss the Supreme Court, before we refer to the contention of the learned counsel for the petitioner. We must reiterate the facts. As we discussed, that Article 21A, titled Right to Education, was provides and which provide that state shall endure or state shall provide free and compulsory education to all children of all age of 6 to 14 years in such a manner as the state may by law determine. And that's why accordingly uh, the 2009 act was enacted by the parliament to provide or to enforce free and compulsory education to all children of the age of 6 to 14 years. So the validity of that act was challenged. In one case, it was the case of Society for Unaided Private Schools of Rajasthan versus Union of India. And this case was decided by the three bench of Supreme Court, two learned judges, learned judges. It was the Chief Justice S.H. Kapadia and Swatantra Kumar, held that the 2009 Act is constitutional valid and shall apply to the following. First, the schools established and owned and controlled by the appropriate government or the local authorities. An aided school, including aided minority schools. An aided school, including minority aided schools, receiving aids or grants to meet all or part of its expenses from the appropriate government or the local authority. A school belonging to the specified criteria and aided un, and unaided non-minority schools not receiving any kind of aid or grants to meet its expenses from the appropriate government or the local authorities. However, it's the two learned judges, Justice Kapadia, Chief Justice Kapadia, and Justice Swatantra Kumar, held that 2009 Act, in particular section, it's the section 12 clause 1 clause C and section 18 clause 3, infringe the fundamental rights guaranteed to unaided minority schools under Article 30 clause 1 of the Constitution, and therefore 2009 Act shall not apply to such unaided minority schools. But differing from the majority opinion expressed by the two learned judges, it was Justice Radhakrishnan, held that Article 21A casts an obligation on the state and not on unaided non-minority unaided minority schools to provide a free and compulsory education to the children of age of 6 to 14. After the aforesaid judgment in Society for Unaided Schools of Rajasthan versus Union of India and others, the 2009 Act was amended by the right of children to free and compulsory education Act, that was Amendment Act of 2012, and by the amendment it was provided in subsection 4 of section 1 of the 2009 Act that subject to the provisions of Article 29 and 30 of the Constitution, the provisions of 2009 Act shall apply to the conferment of the rights of the children to free and compulsory education. Here, Mr. Rohtegi, learned senior counsel for the petitioner, in writ petition submitted Article 21A of the Constitution creates obligation only on the states and its instrumentalities under Article 12 of the Constitution, and does not cast any obligation or duty on private unaided educational institutions. He submitted that the majority opinion, the he submitted that the minority opinion of Justice Radhakrishnan in Society for Unaided Private Schools of Rajasthan, which is Union of India, is therefore correct interpretation of Article 21A. He submitted that Article 21A is interpreted to include the private unaided educational institution within its scope, then it would abrogate the right under Article 19 clause 1 clause G of the Constitution to establish and administer private educational institution. And you know that it is the violation of Article 19 clause 1 clause G, and that's why it will be the violation of basic structure of the Constitution. And another learned counsel or senior counsel which also submitted, it was counsel Mr. Nariman, submitted the word state used under Article 12 of the Constitution would mean that state as defined under Article 12 of the Constitution, which talks of that it includes the government and parliament of India, it includes the government and state of each government of state of each state, and also uh, states or local or other authorities within the territory of India or under the control of government of India. So he submitted that the court. Uh, he also cited one case. It was the case of P.D. Shamdasani versus Central Bank of India. That's a very old case. Was case of 1952. That the language and structure of Article 19 clause 1 clause F uh, and the setting of part 3rd of the Constitution clearly show that the articles are intended to protect those freedoms against the state action only, and hence violation of rights of property by individual is not within the purview of Article 19 of the Constitution. He also submitted and cited the one court's decision. It was the case of Srimati Vidya Verma versus Shiv Narayan Verma, uh, which was related to Article 21. And here, the fundamental rights under Article rights, personal liberty under Article 21 of the Constitution available against only the state, not against the private individual. So he submitted that the word state in Article 21 of the Constitution would not include private unaided education institution or private individual. And Nariman also pointed out that the Constitutional Amendment 86 was amended 86th. It was amended in the light of Article 45 of the Constitution, which states, which provide that the state shall endeavor to provide within a period of 10 years from the commencement of the Constitution for free and compulsory education for all children until they complete the age of 14 years. He submitted that what Article 14 therefore meant was that the state alone shall endeavor to provide for free and compulsory education to all the children up to the age of 14. He submitted that Constitution's 86th Amendment 2002, Article 45 was deleted and its place of Article 21A. Uh, 21A was inserted in the Constitution. He submitted that Article 21A of the Constitution, uh, uh, the word for is missing, but this doesn't mean that the obligation of the state is obligation of the state to fund free and compulsory education to all children up to the age of 14 years could be passed by the state to private unaided uh, educational institutions. He submitted that Article 21A if constitute mean that the state could bypass on its obligation under Article 21A uh, to provide free educational institution, free compulsory education to all children up to the age of 14 to provide unaided school. Article 21A would abrogate again Article 19 Clause 1 Clause G of the Constitution, and that as he cited the decision, earlier decision, that it was the decision of TMA Pai case also, in which the Supreme Court had held that, in case if it is to be asserted to provide education by the to give to give education uh, freely by the unaided private education institution, it would be infringement of Article 19 Clause 1 Clause G. So he referred the decision of TMFI also. So uh, again, Mr. Nariman submitted that the objects and reasons of the bill which became the Act 2009 explicitly state that 2009 is the pursuant of Article 21A of Constitution, but did not make any reference. Did not make any reference. Another important provisions of the Constitution, that is Article 15 Clause 5. He submitted that the validity of the provisions of Act will therefore have to be tested by the reference of Article 21A of the Constitution, not by the reference of Article 15 Clause 5 of the Constitution. And accordingly, both Mr. Rohtgi and Mr. Nariman, Section Section 12, Clause 1, Clause C of the Act, insofar it provides that in a private unaided schools shall admit in class 1 to the extent of at least 25% of total strength of the class, and children belonging to the weaker section and disadvantaged group in the neighborhood, and to provide free legal education till the completion of violation of the right of private education under Article 19 Clause 1 Clause G, and that as it was interpreted in two important cases as TMA as well as Inamtar. They submitted that the majority opinion of three judge bench in uh, Society for Unaided Private Schools of Rajasthan versus Union of India is therefore not correct, and it needs to be reconsidered. And again, uh, Another uh, lawyer, another senior counsel, Mr. Ajmal Khan, also, appearing for the protection for the protection of Article 30 Clause 1 of the Constitution of all minorities, and that he referred to the decision of the court that right from the Kerala Education Bill to TMA to argue that admitting children other than those of the minority community which establish the school cannot be forced upon the minority educations, whether aided or unaided. So they submitted that article, the 2000 Act. They submitted that 2000 Act, if made applicable applicable to minority schools, aided or unaided, it will be the ultra virus to Article 30 of the Constitution. So they submitted that majority judgment of in this court, majority judgment of this court in Society for Unaided Private Schools of Rajasthan has been taken a view that the 2009 Act will not apply to the unaided minority schools but will apply to the aided minority schools. So they submitted that accordingly. The subsection 4 of the Act provide that subject to the provision of Article 29 and 30 of the Constitution. So the provision of Act shall apply to the conferment of rights in on the children of the free and education, compulsory education. So they submitted that this subsection of section of 2009 Act should be declared as ultra virus, as it is going to infringe Article 30 Clause 1 of the Constitution. Here, uh, on other hand, it's the uh, we can say learned additional Solicitor General K.V. Viswanathan, the he replied his he submitted his reply, which was enacted as the what were the reasons of bill which was enacted as the Constitution 86th Amendment 2002, that goal of as you know that the goals have been set out in Article 45 of the Constitution, providing free and compulsory education, and this goal was not achieved even after 50 years of the adoption of the provision, and in order to fulfill this goal, it was felt that new provision of the constitution should be inserted, and that's why 21 was inserted. And in the light of Article 21, or accordance with the Article 21, the 2009 Act has been enacted, which provide uh, which provides for the free and compulsory education till the age of 40, and especially the section of the society, bigger section of the society, disadvantaged group, at least 25% of the strength of the class, and provide free and compulsory education. Here, Mr. Vishwanathan submitted that private educational institution cannot have any grievance in this regard because they are performing functions similar to the function of state or akin to the function of state. He submitted that applying the functional test, private education institutions are also state within the meaning of Article 12 of the Constitution, and therefore the argument of Mr. Nariman, uh, Nariman, that obligation of providing free education and compulsory education to all children of the age of 6 to 14 cannot be passed on the state, cannot be passed by the state to the private educational institutions. Mr. Viswanathan submitted that para 53 of TMFI, which have the right to admit students of their choice, admission of small percentage of students belonging to the weaker sections of the society by granting them free seats or scholarships, if not granted by the government, should also be done. So he submitted the paragraph of 68 of the TMFI also. Uh, this court has also held that small percentage of seats may also be filled up to take care of poor and backward class of the society. He submitted that 2009 Act therefore has provided Section 12, Clause 1, Clause 3, and unaided private school shall admit admit in Clause first to the extent of the at least 25% of the strength and belonging to children belonging to the uh, poor sections or disadvantaged group, and they provide free and compulsory elementary education till the completion till the completion age of 14, and that's why this provision of 2009 Act is not going to declare to be ultra virus, and they're not ultra virus in the light of Article 19, Clause 1, Clause G of the Constitution. And uh, so, uh, ultimately, you know that it's the Article 21A of the Constitution, as we have noticed, states that state shall provide. The Supreme Court, after going through the arguments from the both sides, the the Article 21A of the Constitution, as we have noticed, that the state shall provide free and compulsory education to all the age of 6 to 14 in such a manner as the state may by law determine. The word state in Article 21A can only mean the state which can make the law. Hence, Mr. Rothgi and Mr. Nariman are right in their submission that the constitutional obligation under Article 21 of the Constitution is on the state to provide free and compulsory education to all children of 6 to 14 years, not on private educational institution. So, Article 21A, however, state that the state shall by law determine the manner in which it will discharge its constitutional obligation under Article 21A. So, thus, a new power was vested in the state, enable the state to discharge this constitutional obligation by making a law. However, 21A has to be harmoniously construed with Article 19, Clause 1, Clause G, and Article 30 of the Constitution. So, as has been has been held up by this court in Venkataramana Devaru versus State of Mysore, which was decided in 1958, when the rule of construction is well settled that where there are in an enactment of two provisions which cannot be reconciled with each other, there should be they should be interpreted. A possible effect could be given to both, and this is what is known as the rule of harmonious construction. So here the Supreme Court held that we don't find anything in Article 21A which conflicts with other rights of the private unaided schools under Article 19, Clause 1, Clause G, or the right of minority schools under Article 30, Clause 1 of the Constitution. But the law made under Article 21A may affect these rights under Articles 19, Clause 1, Clause G, and 30, Clause 1. So, the law made by the state to provide free and educational institution, free and educational to the children of the age of 6 to 14 should not therefore be such as to abrogate the right of unaided private educational institution under Article 19, Clause 1, Clause G of Constitution, or the right of minority unaided or unaided under Article 30, Clause 1 of the Constitution. So, uh, in our considered opinion, therefore, by the Constitution 86th Amendment, a new power was made available to the states under Article 21A of the Constitution to make a law, determine in manner in which it will provide a free and compulsory education to the children uh, of children from 6 to 14 years age. And as it was, this goal was contemplated under Article 45 of the Constitution. Uh, be- and you know that so this additional power vested by the Constitution in states is independent and different from the powers of state under Clause 6 of so is independent different from the power to the state under 19 Clause 6 of the Constitution, and has affected voluntar- uh, uh, voluntariness of the right under Article 19 Clause 1 Clause G of the Constitution. By exercising this additional power, the state can by law impose admission on private unaided schools, and so long as the law made by the state in exercise of this power under Article 21A of the Constitution is for the purpose of providing free and compulsory education to the children of the age of 6 to 14, and so long as the law forces admission of children of poorer, weaker, and backward section of the society to a small percentage of seats in private education institutions to achieve the constitutional goal of the equality of opportunity and social justice sets out in preamble of the Constitution. Such a law would not destructive of the right of private unaided education institution under Article 19, Clause 1, Clause C of the Constitution. And under Article 30, Clause 1 of Constitution, all minorities, whether based or religion or language, uh, shall have the right to establish and administer the educational institutions of their choice. Religious and linguistic minorities, therefore, have a special constitutional right to establish and administer educational institutions or educational schools uh, of their choice. And this court has repeatedly held that the state has no power to interfere with the administration of minority education institutions and can make only regulatory measures and has no power to force admission of students amongst the non-minority communities, particularly in minority schools, so as to affect the minority character of the institutions. Moreover, in uh, Kechvananda Bharati, Sripada Gal Baru versus State of Kerala, it the Chief Justice Sikri has even gone to the extent of saying that Parliament cannot, in exercise of its amending power, abrogate the rights of minorities. So the Supreme Court held that when we look at 2009 Act, we find that Section 12, Clause 1, Clause B, read with Section 2 and Clause 3, provide that an aided school receiving aids and grants whole or part of expenses from the appropriate government or the local authority has to provide free and compulsory education to such proportion of school children admitted therein as its annual recurring aid or grants so received years to annual recurring expenses subject to the minimum of 25%. So thus a minority aided school is put under a legal obligation to provide minority free and compulsory education to the children who need not to be children of members of minority community which was established the school. So we also find that under section 12 clause 1 clause C read with section clause clause 2 clause N clause 4 uh, an unaided school has to admit into 25% of the strength of the class children belonging to the weaker section and disadvantaged group in the neighborhood. So, hence, an aided minority school will have a legal obligation to admit children belonging to the weaker section and disadvantaged group in the neighborhood who need not to be children of the members of the minority community which has established the school. So, while discussing the validity of clause 5 of Article 15 of the Constitution, we have held that members of the communities other than the minority community which has been established, the school cannot be forced upon a minority institution because they may destroy the minority aided or unaided. So, in our view, the Supreme Court held that in our view, if the 2009 Act is made applicable to the minority uh, schools, either aided or unaided, uh, the right of minorities under Article 30, Clause 1 of the Constitution will be abrogated. Therefore, the 2000 Act, insofar is made applicable to the minority schools referred in Clause 1 of Article 30 of the Constitution, is ultra vires the Constitution. So, we are thus in the view that the majority of judgment in uh, society society for unaided private schools of Rajasthan versus Union of India, insofar as it holds that 2009 Act is applicable to aided minority school is not correct. And in the results, beholds that the uh, 93rd Constitutional Amendment 2005 inserted Clause 5 to Article 15 of the Constitution and 86th Constitutional Amendment 2002 which inserted Article 21A of the Constitution do not alter the basic structure of the Constitution or framework of the Constitution and are constitutionally valid. We also hold that the 2009 Act is not ultra vires to ultra vires the Article 19 Clause 1 Clause G of the Constitution. So, however, hold that 2009 Act insofar is applies to the minority schools, aided or unaided, covered under Clause 1 of Article 30 of the Constitution and is ultra vires. The covers under Article 30 of the Constitution is ultra vires. The Constitution accordingly writ petition C filed on the behalf of Muslim minority. Managers Association is allowed. And writ number, lot of writs, that number 416, 2012, 152, 2013, 60, 2040, 95, 2014, 160, 14, 128, 14, 144, 14, like that, so on, filed on the behalf of known minority. Private unaided education institutions are dismissed. Means that there is no violation of their rights under Article 19, Clause 1, Clause G, and they are supposed to admit little percentage of weaker sections to their schools, to their education institutions in first class for the sake of Article 21A, as well as for the importance of Article 15, Clause 5 of the Constitution. So it's all related to the Bramati Educational and Cultural Trust case. Thank you a lot. Next time we will meet for another important articles like Article 23 and 24. Thank you. Thank you.